Yeah, so my research, looking backward at how courts have thought about robots, one of the things that comes across is that judges often have an inaccurate mental model of what a robot is like. And specifically, they think of a robot as being totally without discretion. And the problem with that, of course, is that if it were ever true, it's less and less true today. Robots are capable of so-called emergent behavior, behavior that was never fully anticipated by the programmer. Um, and so, in today, I'm working, closely with policymakers as well, and they too tend to have that sort of idea about what a robot is. And when they learn that robots are capable, or artificial intelligence is capable of truly surprising behavior, they get very nervous, and then they wonder whether it should be deployed at all. But of course, the best thing we can do is we can try to maximize the advantages of this technology and its propensity to surprise us, while hopefully minimizing the harms.
Okay.
So, the thing about courts is that they don't have a tremendous amount of opportunity to necessarily learn about technology, right? I mean, they have the matter before them. And maybe they have expert witnesses or amicus briefs, but it's not as though they are learning more and more over time. At least with, say, a federal agency, you might be able to accrue expertise in robotics. The problem has been that each of the federal agencies is handling their own robot, if that makes sense. So the Federal Aviation Administration thinks about drones. The Department of Transportation thinks about driverless cars. And they haven't necessarily talked much to each other. They have engineers there, but those engineers are not learning from each other. I think a first step would be better communication among agencies to find common issues in computer science that relate to the robotics that they're thinking through. I proposed in a Brookings Institution white paper that maybe it's time for a federal robotics commission, that is to say, at least an advisory body that is able to get deep expertise in this technology and disseminate that expertise where needed to Congress, to state lawmakers, to courts, to other agencies. But it is a non-trivial challenge attracting high-quality technologists to the government, where there are competing offers from Uber and Apple and Microsoft. Yeah. So, while I do think that robots present intriguing and novel puzzles, I don't at all think we're writing on a blank slate. I think there are many models we could be turning to in order to try to domesticate some of these problems. But that doesn't mean that they're easy. So, for example, with the internet and with the computer and with our devices like our phones, we've taken for granted the fact that we're going to buy this little platform, and then lots of other people are going to make it great. You know what I mean? You buy a computer and you buy software from a dozen different providers. You buy an iPhone and you don't just get your apps from Apple. And that also is going to be the way forward with all kinds of robots, drones, personal robots, cars. There's going to be that app ecosystem, right? But whereas the law has had no problem limiting liability when an app, does something involving bits, like loses your, important paper, you don't get to sue, Dell or Microsoft for that. The law strikes a different balance when bones and not bits are on the line. And so part of what has made the internet so empowering and generative and such an unstoppable engine of commerce has been early decisions to immunize platforms for what users do on those platforms. And if we want the same kind of innovation ecosystem with robotics, we'll have to think about how to do that. But courts and lawmakers will be reticent, right? So, one model you might think of is gun legislation, right? So in gun legislation, so many people were suing gun manufacturers for what people did with guns that they wound up having to lobby Congress and ultimately get a law passed, right? Basically just saying, you may not sue a gun manufacturer if the only basis is the fact that someone used it to shoot somebody else, right? That doesn't mean you can make, crummy guns that blow up in your hand. It doesn't even mean that you can make a gun that you advertise as being semi-automatic that's easy to make automatic, right? It just means that if people do crazy things with guns, you can't sue the manufacturer. Maybe we could consider that model with something that is arguably less dangerous and more innovative than a gun. There's also the prospect that really otherwise valuable systems, safety systems, for example, will on the margins create a problem. And so, for example, the dream of driverless cars is that they will shrink the universe, right, of fatal accidents that people cause, and that it will cause it to be much smaller and circumscribed within the original liability. But the truth is a little different. The truth is that it will shrink the amount of liability and the amount of car accidents, but it will create a small, if you imagine a Venn diagram, a small amount of them that wouldn't have happened had a human driver been in the area. So what do you do about that potentially massive liability, right? So for example, a car may always be better than I am at avoiding a shopping cart. And it may always be better than I am at avoiding a stroller. But what if it's confronted with a stroller and a shopping cart at the same time, right? I know to plow into that shopping cart, but the car may not. And if ever it were to make the wrong choice, the headline would read, robot kills baby to save groceries. And that is the end of driverless cars in America, right? And it gets us back to that big area where, tens of thousands of people are dying because of human error in cars. So that's as much a PR or optics issue as it is anything else. But you could also imagine a model like vaccines, where not to be a conspiracy theorist, and I'm not, but I mean, of course, vaccines do harm some set of people. Some set of people have bad reactions to vaccines, and as a consequence, there are vaccine courts that people have to go to in order to get compensation. But they were set up by the government to immunize manufacturers of vaccines, because without that legal subsidy, there wouldn't be a business case to make vaccines that we all need. You know what I mean? And so we've identified vaccines as something that's good net in a health context for society, but requires some degree of limitation otherwise, and some mechanism to address the harms they do cause. Part of my project is to create a kind of a method, or if that's too grandiose, a kind of an approach to thinking about the effect of emerging technology on law. And part of that involves careful definition of the technology, and part of it involves figuring out how the technology changes human experience and thereby challenges assumptions that the law holds that maybe no longer obtain. And there are a number of different examples of that. For example, that a surgeon would be a human person and co-located with the patient. Why is that important? It's important because if a person is using telerobotics to do surgery in Maine from California, it is not clear whether they need to be board certified, for example. Or if Google realizes its vision with Johnson & Johnson to create automated surgery, it is not clear who needs to be certified at all, right? All because certification assumes a human surgeon. Another example is emergent behavior that, as I mentioned at the top, surprises us. Just today, there's been an enormous amount of coverage around Microsoft's chatbot called Tay. Tay is a fun chatbot they put on Twitter, and within hours, it began denying the Holocaust. It began calling people horrible, vitriolic, racist names. Fundamentally embarrassing Microsoft and causing them to pull the plug on it for now. How did that happen? It happened because trolls on the internet figured out how to nudge it into this inappropriate behavior, right? Which surprised Microsoft. Just as the creator of one bot in Europe was surprised by the fact that the bot unexpectedly specifically threatened a fashion show in Amsterdam, right? Now, to the people who get threatened or called these terrible things, they feel harm. But there's no perpetrator behind the harm, according to the law. Why? Because you need to commit a crime, you need mens rea, right? You need an intention. To commit a tort, you need the action to be foreseeable, right? And in the absence of foreseeability or mens rea, it is hard to keep people accountable, anyone in particular accountable, for emergent behavior in either civil or criminal law. So imagine, for example, that you are a French citizen, and under your law, it is unlawful to deny the Holocaust, and yet you are now in conversation with some entity that is doing just that. But Microsoft doesn't want to deny the Holocaust, of course. Of course they don't. Just as Google did not want to label an African American couple as gorillas, and yet that's exactly what its image recognition software did, and deeply offended those people, right? Now, the problem is you could just say, well, emergent behavior is bad, right? I mean, so we just shouldn't have it. You know what I mean? Like, smoking is bad, right? So we shouldn't have it. I mean, but that's not the case, right? Because emergent behavior is also extremely useful. For example, I gave this example in my talk of Amazon, the way it organizes its warehouses, right? It uses a system that not only where robots retrieve things from the warehouse, but they also constantly update where the inventory is located to maximize efficiency. And they do that in a way that, you and I wouldn't do it, right? We might put things in alphabetical order. We might put things next to each other because we think that they're similar. You know what I mean? Whereas the algorithm will organize the warehouse according to what people happen to order at a particular time in a particular order. You know what I mean? And so no human would be able to fathom in advance, and yet it's more efficient. So the idea of emergent behavior is precisely that it'll solve problems the way we wouldn't. That's why it's useful. It's fast, it's unsupervised, but of course the downside is that it sometimes does things that have a social meaning that the algorithm couldn't possibly fathom. Some people argue with robots for a kind of a strong exceptionalism. The idea being that something about robots will cause us to need to make new laws. And I think that entirely new laws. And I think there's truth to that if we believe that artificial intelligence will ever come to approximate human intelligence, and then we'll have these non-human, entities. That would break the legal system. We'd have to do something about it. But for the most part, what new technologies do is they elevate the importance of a doctrine that already exists, or they vastly reduce the importance of a doctrine that already exists. And I think those kinds of things would happen here. So, for example, with the problem of there being no mens rea, right, for an emergent harm, you might think about using strict liability. Now, you wouldn't attach the same, jail time or this, you know what I mean? Like you'd have a lower penalty. But typically, we have strict liability in crimes, but they tend to be crimes where the stakes are either very, very small, like your taillight is out, or they're really big, like with statutory rape. We do not, in most jurisdictions, you do not have to intend or even know that the person's below a certain age in order to implicate the statute, right? Maybe strict liability in crime will become more important. Conversely, in tort law, which is what I teach at the University of Washington, proximate causation is enormously important. It just, foreseeability comes up everywhere, Maybe foreseeability won't be so powerful anymore. Maybe it'll be something else, you know what I mean? And so that wouldn't necessarily fundamentally, require us to remake the law. It would just require us to, in some circumstances, de-emphasize the role of proximate causation, right? And you see that with other technologies too, if I may run on. I mean, when trains came about, we decided to use negligence to mediate the fact that trains were so immensely useful, but they were killing people and starting fires. You know what I mean? They were bad news at one level, but they were so useful. So we took negligence, which was a backwater. No one used negligence really for anything, and elevated it to the status that it has today, where it subsumes nearly everything else in tort law. You know what I mean? And so I've been looking to everything from maritime law, to tort, to to try to see if there are these sort of useful little tools lying around that we might be able to elevate